Thank you very much, Lloyd. It's a great pleasure to be here and to talk to you. A quick word about Americans for Clean Energy Grid. It's a project of the group that I run in Washington, D.C. called the Energy Future Coalition, which itself is a bipartisan project to try to identify good, constructive energy policies that should not fall into the partisan chasm, that should get support across the political spectrum. And we think that clean energy transmission is one, that everybody benefits from modernizing, extending, and building out the high voltage grid across the country to achieve greater reliability, better economics, and access to the immense resources we have of energy in lots of parts of this country, and we're in one of them, that's for darn sure. I apologize that I'm going to have to leave later this afternoon, not right after my presentation. I'd love to stay for the rest of this. It's a terrific program, Lloyd. I have an obligation tomorrow in Washington. Actually, I have two obligations, one of which is a conference talk, the other of which is I'm teaching the very first class I've ever taught in my life as a professor adjunct at Johns Hopkins University on energy policy. So I'm nervous about that, but I think the students have the greater reason to be nervous, so we'll see how that goes. But I got to be back for it. It's the first one. In any event, what Lloyd has asked me to talk about is the decision that came out of the 7th Circuit Court of Appeals in Illinois a couple months ago in the case of Illinois versus FERC. And in particular, an aspect of that decision which raised what's called the Dormant Commerce Clause. And before the Dormant Commerce Clause makes all of you dormant, I'm going to try to get into the details and give you some outline of it. The 7th Circuit decision was basically on appeal of the FERC decision, Federal Energy Regulatory Commission. I'm sure I didn't need to say that. FERC decision that upheld Midwest Independent System Operators' cost allocation for the set of 16 multi-value projects that MISO, Midwest Independent System Operator, had approved for transmission upgrades in the MISO region. And MISO had spread those costs among the states in the region on the basis of the electricity consumption of those states. And two sets of states, one led by Illinois, one led by Michigan, objected to that and appealed the decision. And this was the court's decision essentially upholding what FERC did. So there were a number, so what I'm going to do is talk first about the decision, second, define what a Dormant Commerce Clause means, third, talk about where the action is on the constitutionality of renewable portfolio standards in light of the Dormant Commerce Clause, and then finally give you my own thoughts as to what this all means. And I'm going to try to get through it quickly. The 7th Circuit decision was before a 3-judge panel, but was written by Judge Posner, who is a very celebrated conservative judge on that panel. Basically said FERC did it right, that yes, there was no way to be precise about allocating costs to those who benefited from each of these projects, and that to spread those costs broadly over the states that consume power was an appropriate way of dealing with the uncertainties of knowing exactly how the benefits flowed. And they found that you couldn't specifically allocate the benefits, and that you couldn't do it even if you went back through discovery and hearings the way the plaintiffs asked. But beyond simply saying FERC did it right on the costs, FERC said, I mean, the court acknowledged that the states throughout the MISO region have renewable portfolio standards, and that these 16 multi-value projects were essentially adopted in service to the ability to meet those standards. And that was a valid exercise of the authority that those states had given to MISO, and that they had allocated it appropriately over the total energy. They didn't try to, some of the complainants said, oh, they should have pegged it to the peak energy. which would have given a different allocation, but the court said, no, total energy is the right way to do it. And that they recognized that the market as a whole was going to benefit, as MISO had analyzed, from the availability of this new and relatively low-cost, high-value wind energy, and that was going to be, again, according to MISO, more of a savings than the cost of the transmission it took to bring it to the market. And so, from the perspective of those who would like broad regional cost allocation of transmission capacity and transmission investment, particularly for making access available to high-value renewable resources that are otherwise off the grid, this court decision went right down the line with MISO in saying, yes, you can do it this way. And those have been controversial issues at FERC in Washington and other transmission regions. And so from that perspective, it was a very positive decision. And I note at the bottom of this that the only element of the decision that the court rejected actually sided with MISO against FERC, where FERC said, yeah, some of this power goes through MISO to PJM, and even though MISO and PJM have a sort of cost-sharing deal, we're not going to pass any of the costs through to PJM because they weren't in the planning of the MVP projects. And the court said, oh no, if the PJM utilities are getting some of the benefit of these projects, MISO should negotiate with PJM, and FERC should insist that they reach an appropriate allocation of costs through to PJM. So it's not just regional transmission costs that this decision said could be broadly allocated, it's interregional transmission costs. And FERC was essentially given the court's approval to negotiate that process. And of course, all this in the context of the fact that FERC doesn't have the approval to build transmission. They can simply set rates and set conditions for the use of transmission in interstate commerce and for wholesales of energy. So it may have occurred to you that I like the decision myself for Americans for a Clean Energy Grid. That's what we're all about, is trying to develop broad, regional, high voltage capacity that allows us to move energy from where we've got it to where we need it and achieve the maximum economics and reliability in doing it. But in the decision there was language that rejected an argument that Michigan made. And Michigan made this argument. It said, we shouldn't be allocated costs for projects in Minnesota and Iowa and Wisconsin and elsewhere. We've got a state law that says we can only credit against our renewable portfolio standard renewable energy that comes from Michigan. So therefore, it's not fair. Well, Judge Posner kicked that ball out of the stadium with language in which he basically said, Michigan's law is blatantly unconstitutional under the Dormant Commerce Clause. So that got a lot of attention. But, and here I go back to law school a bit. That's what's known as dictum. Dictum is language in a court decision that may be perfectly right, may be perfectly sound, but it doesn't go to the issue the court was deciding, and therefore it has no legal effect. Nothing in FERC's MISO MVP cost allocation decision had anything to do with Michigan's in-state preference for renewable power. That wasn't pending before FERC, it wasn't in FERC's decision, and therefore it wasn't pending before the Seventh Circuit. So Michigan raised that as an argument why FERC's decision wasn't good for them, and the court basically dismissed that argument with the answer that that's unconstitutional. But that didn't overturn Michigan's law, because that's not what the court was deciding. So the court's language has no legal weight, and I think the court, was a bit cut and dried on the Dormant Commerce Clause. There's a little more to it than that. So basically what I think Lloyd asked me to do and what I'm going to try to do is tell you what really is going on and what's likely to go on with regard to that. What is the Dormant Commerce Clause? Well, first, what's the Commerce Clause? That's the clause in the Constitution that said, federal government has the power over trade with foreign nations and among the states, i.e. the federal government controls interstate commerce. That's all it says. It doesn't say anything about the states not having power, but the courts quickly, over a long time, have interpreted that to say, well, if the federal government has the exclusive power to control interstate commerce, there's no room for the states to control interstate commerce. Therefore, the states are barred from having policies that would burden or control or discipline interstate commerce. And so what has that come to mean? What that's come to mean is that any state which adopts a policy that has the effect of limiting, suppressing, or banning interstate commerce is going to have a hard time having that policy pass constitutional muster when challenged. Now, there are 3 refinements that have been adopted over the years to that policy. The first is that if a state has a compelling state interest, then it can suppress interstate commerce. The example that is always used is that if there's a contagion, a typhoid epidemic in the next state over, the state can say, oh, we're going to stop train and bus traffic, we're going to stop people from coming to that state to this because we don't want that epidemic here. Well, that's an imposition on interstate commerce, but that's a compelling state interest to keep a plague from coming into that state. That's the level of interest it takes. I don't know of a single case which has found that level of interest to suppress interstate commerce. The second one is that if there's discrimination against interstate commerce, but not a bar. In other words, it's a burden on interstate commerce, but it doesn't appear to be any major intent. You have to weigh that burden against what does the state get out of this in-state, and the burden is on the state to show, hey, what we're getting out of this from local policy vastly outweighs in benefit the minimal burden that this places on people elsewhere. And then there is no exception if the rationale for the state's action is, well, that's there and this is us. If it's a geographic rationale, that's a prima facie violation of the Dormant Commerce Clause, and those laws are basically thrown out right away. All right, so what does this mean applying to renewable energy? Well, what it means, first, the electric grid has been considered and has been found by the courts to be essentially the epitome of interstate commerce. The power in these lights may have come from Wyoming, may have come from Idaho, may have come from any place in the whole Western System Coordinating Council. It's interstate, and the electrons can't be tracked, they can't be moved, and they're all the same. So anything that goes to electricity commerce is almost by nature interstate. Now, a state can, however, spend its resources, spend its taxpayers' money, spend its policymakers' time trying to find ways to favor in-state development. That's not a problem. The state of Wyoming wants to create a tax credit for Wyoming wind development. They don't have to give that tax credit to people from Colorado or Iowa or anyplace else. No, they can do that. What they can't do is create a policy that costs people in Colorado, Iowa, or anyplace else money or problems to bring their power into Wyoming. That's the burden. That's the effect of discriminating against interstate commerce. So a direct state subsidy is fine. Direct state participation, if the state wanted to invest in wind development, that's fine. But they can't take an action or any combination of action that would discriminate against out-of-state producers. So if the effect of a policy is to create a difference in the in-state market treatment as a function of out-of-state origin, that policy is per se a violation. Any clear in-state preference or mandate is deemed to have that effect. And so what else does that mean? Well, what I've told you is that Seventh Circuit decision, that was dictum. Nobody can cite what Judge Posner said, therefore, this state's RPS is unconstitutional. But there are cases that are pending and that are moving forward where that is a matter before the courts or before a state regulatory agency, and here's two. In the American Tradition Institute versus Colorado, initially filed in 2011, they challenged the Colorado statutes that favored renewable energy, favored local energy, created a preference for utilities in meeting the RPS if they bought renewable energy from Colorado sources. And the American Tradition Institute is challenging that. But they're not exclusively challenging the renewable aspect of that. In that case, the American Tradition Institute is arguing, and all electrons are the same, so it's discrimination for Colorado to favor renewable energy versus conventional fossil fuel-fired power. That's discrimination. We've got one big wide western grid. The electrons flow anywhere. The electrons are all the same. You can't have a policy that favors distributed generation systems in your communities as opposed to my big coal plant or somebody else's big dam or somebody else's big nuclear plant on the broader grid. That's discrimination. In my view, that case isn't going to simply turn on in-state versus out-of-state. And in fact, it could turn against the plaintiffs on the basis that no, renewable energy is qualitatively different from and susceptible to having state policies that recognize that difference, different from fossil-fired power or central power. And distributed generation has value that it makes it a different product. So we're not, when they're favoring distributed generation, they're not disfavoring remote central generation, because that's different. So I think the American Tradition Institute case is very important. If the court finds that they're right, that doesn't only deal with the in-state, out-of-state issue. That would blow up the basis for renewable portfolio standards by saying you don't have the constitutional right to treat any electron differently than any other electron, regardless of how it's generated. And so that would be a major league finding. And you know, this stuff is wending its way. It's probably going to get to the Supreme Court in some form or another. The application of Cowlitz County in California, Cowlitz County is a Washington County rural co-op. And they've made a lot of investments in wind generation, and in part they made those investments because they thought, you know, those people in California, they're, you know, just keep raising the renewable portfolio standard they're trying to serve. We're going to have a lot of good renewable energy we can sell when we're not using it. And then it turns out, well, California's got a in-state preference. And so they challenged it, and they challenged it at the PUC in California, because the PUC had the job of writing the rules for how you would fulfill the RPS requirements in California. What's happened is not a lot, and in part, the Cowlitz County folks are saying, hey, PUC, wake up. You're not getting these rules out. We're sitting out here trying to cut deals, but nobody will cut them with us because the rules aren't clear. Meanwhile, they seem to be a lot clearer for people who are in California selling power. And so there's, you know, one could accuse, far be it from me, one could accuse the California authorities of, you know, sort of delaying the resolution of the rules and letting the world work itself out because people aren't sitting around. They still need to go out and write contracts for renewable energy while all this stuff is up in the air. Well, where are we going to write it? Well, we know we're safe if we write it with somebody who's already connected to the California system, the California grid, or has the capacity that is subscribed by somebody who operates a balancing area in California. That's the kind of criteria they are using. All right, so those are two of the cases that are pending. Another one in Michigan. Michigan said, we're going to buy renewable energy from any place, but we're going to put a tax on the sale of renewable energy to Massachusetts consumers. And we're going to have a tax rebate for in-state producers. Well, that didn't pass muster. And when they were sued over that, they promptly settled because they knew they were going to lose the whole statute. By settling the suit with the people who brought the suit, they got exactly what they wanted, But the statute survived, although that in-state preference thing, they're doing that differently now. They still have an RPS. They didn't lose the whole statute. So what are the states using as strategies to keep their RPSs alive? You know, the one is sort of the fait accompli, you know. If it goes for 2 or 3 years, where the effective force of an in-state preference is in effect, by the time the court throws it out, you may already have fulfilled the RPS mandate with in-state requirements. The second is to cut a deal, settle, sue and settle. And that's where you give the initial plaintiffs what they want, and then somebody else has to come and sue you again to get your law thrown out. The third is over-specificity. One of the things that Colorado did in its RPS was say, we'll buy renewable power from anywhere, as long as it's defined precisely the way the Colorado statutes define it, knowing full well that the other states had their own and different definitions of what's renewable power there. So how is somebody out of state going to prove that their renewable power meets the Colorado definition? It's just that kind of sort of bureaucratic viscosity that makes it hard to do it. That's a burden on interstate commerce. Is that enough to get the Colorado statute thrown out? I don't know. I mean, they can certainly define renewable energy the way they want to. Finally, subsidize and tax at retail. If you have a tax on retail electricity, well, that's a state function, state regulated, state set rates, state regulated utilities, and you can put a tax on retail electricity. That's perfectly fine. Okay, what do you do with the revenue from that tax? If you turn around and use that revenue to subsidize in-state development of renewable energy, it's not clear. It's not clear that that is going to be seen as a violation of the Dormant Commerce Clause. So I see a few of you out there getting dormant, so I'm going to wrap up. What's my bottom line? I think there's no question that a direct mandate or direct preference is unconstitutional. That a state cannot simply say, we're going to have a renewable portfolio standard, you only can meet it with renewable energy bought in this state. No. So, and there's no question that direct support for renewable energy development is constitutional, as long as it's not at the cost of out-of-state sellers. But broadening the Commerce Clause challenge to introduce challenging renewable or distributed energy by itself, like say plaintiffs did in the Colorado case, well, I think that muddies the waters, and it may make the decision in that case a lot less clear and have less weight as a precedent than it might otherwise. And finally, I think states are going to continue to try to find ways of promoting in-state development of clean energy, and there are devices they can try to use, and it's going to be whack-a-mole. Different states will try different things, and out-of-state sellers of renewable energy are going to be essentially compelled to go in and whack each of them to, you know, there's not going to be one clean, one-shoe-fits-all rejection of an in-state preference, given the kinds of options that states have. The utilities themselves, hey, it's pass-through for them. You know, they're not going to take this fight up against their own state government and own state regulators and own state, in-state economic interests. So it'll fall to the out-of-state sellers to carry the legal weight of these arguments. And in the meantime, the RPSs will still be in force and still be accumulating contracted volumes of in-state renewable energy. So that's a summary of what the Seventh Circuit decision is. I'm happy to try to answer any questions. And it's still a game in progress.